If I were to ask the people at our headquarters or in many of our offices what they considered some of the biggest data protection or privacy concerns facing our company, they would hands down immediately say the possibility of a data breach. I think that's no surprise to anyone in this room, but given a lot of recent developments regarding notice that is required and the change that could have, or the impact that could have on civil liability, and reputational harm is something that is of key concern, especially when you take into account jurisdictions that may be affected with data subjects with no notice obligation and those that do. Would you, for example, if you were the general counsel, advise your company board to provide notice to everyone or just those where notice was required? And once you did that, if someone didn't receive notice, would you seem like a jerk for not providing notice simply because you weren't required to do so? Also, when you do provide notice, let's say you have 3 data subjects that have been affected by a data breach in a jurisdiction that requires notice, do you, by providing notice to them, subject yourself to additional fines or other regulatory actions in those jurisdictions because you want to do what's right? It's probably unlikely that those 3 data subjects would bring it to the attention of regulators, but even so, you are putting yourself out there. And so these are some concerns that we really have to deal with. The other thing that is of primary concern is how do you deal with legal actions in one jurisdiction requesting data in another? I know that is something that U.S. Courts generally, when they issue orders or requests or discovery requests, it's something that European companies have to consider quite carefully, because by complying with those discovery requests or other legal valid processes, you could be subjecting yourself not only to civil liability, but criminal liability. And so when you have the choice of paying a fine or going to jail, which would you choose? Now, neither is really very appealing, but sometimes those are the types of decisions that people are faced with. I've actually spent quite a bit of time recently on 2 different requests from U.S. courts requesting information from our European operations, and had to actually explain to the lawyers in the case as well as the judge why exactly we couldn't just provide all the information they were asking for. To me, that was quite surprising, but it is something that does happen and did complicate the legal proceedings quite a bit. The other issue that we're facing is that the current laws and regulations that apply to multinational companies don't take into account the increasingly complicated environment that's out there. And I'll give you an example. We at Ingenico, one division, is a payment service provider, which is not something that's really recognized in the United States, but still exists, and we do have offices in the United States. But as a payment service provider, we oftentimes collect personal information from consumers who have visited a particular website that website itself does not collect. Now, we process that information on behalf of the website owner, but again, because they don't actually own that data or possess that data themselves, where exactly would that fall under all the various privacy regimes that we've discussed over the last couple of days? It's also a problem when you take a look at these privacy policies. In an ideal world, I could read every privacy policy of every company for which we process payments and make sure that in that privacy policy, it informs consumers appropriately that their data might be provided to us for purposes of processing a transaction. In actuality, I don't have the time to read 15,000 privacy policies and keep monitoring them day by day. So what do you do? And if someone were going to be upset that, for example, we took their payment data and in the aggregate used it to spot fraud trends or to create tools so that we could make sure that there weren't counterfeit goods coming into Europe, would that be something that's acceptable? And I'm not sure that the current privacy regime, at least globally, actually takes these types of considerations into account.